let's look at this stupid letter she wrote. I honestly, guys, I don't know if I can sit here and this whole thing to y'all. It drives me nuts. Have y'all seen it? I'm sure y'all have. It's been out for a while. She wrote it on January 19th, didn't she? It was January 19th. But one thing I noticed was her little bullet points at the end here. So she says the trial court may hold one or more pretrial conferences to consider such matters as will promote. I'm gonna read exactly what it says. So if it sounds weird, it's not me. It's Psycho Sarah. As will promote a fair and expeditious trial. The defendant must be present at any pretrial conference unless the defendant's presence is waived in writing or on the record by the defendant or by the defendant's counsel with the defendant's consent. In support, the defendant alleges as follows. Number one, their pretrial conferences are for my personal individual criminal care. If professional YouTubers, am I considered in that? I don't know if I'd call myself a professional, but news channels and court TV, etc., are given permission and allowed entry to the courtroom for viewings, and the judge also is allowing the conferences to be streamed live with all the court minutes uploaded to the internet and world. I, the defendant, should be included foremost. I may not have regular, consistent update or communication with my court appointed attorney, and by attending all my PICs, is it PTCs or PICs? In hearings, I will know current status, important dates, casework being completed, changes in parties, time frames, expectations, all pertinent information. I, the defendant, have a right to know I, the defendant, have a right to know, want, and need to regarding my care. All information is important, relative, and necessary to me. I am not consistently included in the certificates of service and sent copies of any documents being filed in court regarding my case, as requested numerous times by the defendant in writing and verbally in the court, neither by the judge, the court, or my attorney. By attending my pretrial conferences, I will know what documents have been filed, need to be filed, and will be for and in my care. Another way I can know what is going on in my care and being worked on. In complete overall support, it is my right by law as an individual, defendant, and inmate to be included in any and all development made in my case. Sorry, I keep saying care, but she means case. Okay. She writes, her R's are weird. It also is my right to finally achieve success in any and in every aspect possible in my case. By attending and being included in my pretrial conference and hearings, said success can and will be accomplished fairly, faster, properly. Really? Really, Sarah? Faster? This woman, she needs a Xanax. Wherefore, the defendant, Sarah Boone, respectfully asked the Honorable Court to grant my motion to be included going forward to all defendants' pretrial conference and hearings. Now, we know this is pretty much the same thing she had said to her first judge, right? Can't even talk, sorry. Let's see. So this was January 19th when she sent this to this judge. And, it's so funny because she tries to use all these big words and sound like, an educated individual. But she writes just as if she's yelling at him, like she just was here just a few minutes ago that we saw. Should we watch it again?
I've been here for 4 years and I'm tired of being here and I'm tired of going through all of these attorneys, which are not my fault. But when 100 days have passed and I haven't heard or said or done anything other than try to figure out where you are because your phone doesn't work, I'm not a bad person because of that.
The letter. All right, here we go. Finally, this is how she's Honorable Judge Cranick. Finally, a new judge. It's strange how the Lord works, as I was in the process of trying to disqualify Wooten after being my judge 4 years, and me still incarcerated with nothing to show other than 7 different attorneys, not by my choice. News clips of me walking in and out of the courtroom, and everything relative to my care permitted to be slathered on the global internet and in which I have not seen myself. You know what she and Letitia Stouch have in common? They do not know when to add a period to the end of a sentence. That look at it. That is a paragraph that she turned into one sentence. Okay, finally a new judge. That's the difference. Okay, so 3 sentences. Good Lord. Okay, I felt he was the ticket holder to my overall no, I'm sorry. I felt he was the ticket holder to my overly hyped, illicitly distributed, misconstrued criminal case, and great reason I am still here again, ongoing 4 years and 7 attorneys later, again, in quotations, not by my choice. See my letter dated June 29th, 23 on the clerk's website. Not by her choice. No, she didn't do it. It has nothing to do with her. You don't think you know how people say to somebody, they say, like someone if they're having issues and they keep having issues, at some point that person has to look at themselves and go, is it me or is it really everybody else that I come in contact with? I don't think Sarah's read that memo yet, y'all. While still waiting to properly elucidate, she looked that up. She looked that one up. The court, public, and world. And after she's trying to say, I think it's another word for educate or inform, I think. And after whatever the dysfunction was in the attendance part of my most recent PTC status hearing, which I am trying to ensure my automatic attendance futuristically, please see my draft motion included. I am still trying to have my attorney submit on my behalf. I want to bring your judicial attention. Who does that sound like? Who does that sound like, guys? Your judicial attention. She just needs to represent herself. This hooker is driving me insane. Okay. The following information so you and the world are aware of it. It is not I am it is not I who I am ever delaying trial, as Wooten inappropriately accused me of doing part of a hearing. Especially now you have mandated a trial date to be had in May with no further continuances, leaving less than 4 months to put together and complete what should and could have been done already. What happened in all the 4 years prior, she question marks. Please see all my correspondence online. To date, Winston E. Hobson has not. Okay, here she's going. She's going off on these are her notes. To date, Winston E. Hobson has been my court-appointed attorney for 133 days and counting. I mean, that's all she can do, y'all, sit there and count the days, right? To date, Mr. Hobson has only met with me one time for a total of 3 hours on November the 7th of 2023. To date, no phone calls have been received by Mr. Hobson as his phone does not work properly for further immediate much needed communication to be made between client and attorney. Why do her attorney's phone always break? You think that do you think they changed their number? Or do you think they purposely give her a bad number? Or is it one of those numbers that's like it goes straight to like a voicemail thingy? Maybe that's the number they're giving her. Can you imagine if she's left voicemails and what they sound like? Oh, y'all. All right. To date, I have mailed 5 letters to Mr. Hobson trying to communicate my urgent need to speak with him. Oh, okay. 5 letters. Wait, when did she get this guy? January the 29th was when they canceled the hearing and the trial. Was that when she was assigned the new one? I think it was. So, I mean, no, not January 29th. When was she assigned the new one? Let's see. I'm going to go back to that. Let's finish the letter. Y'all know it's like squirrel. I get off on a tangent. Okay. I'll go back to the docket and we'll look over some of that stuff. All right, let's see. To date, I sent one letter to the investigator in my case to contact Hobson to contact me. Oh my gosh, she's got his number too. And see if he can assist in correcting the phone problem. Also to inquire when anyone is coming. I bet the investigator has probably tried to quit her too. To date, I feel I am not being included or heard or cared about in my case. Again, from the continued miscommunication again with Mr. Hobson and time-consuming undiscussed entries are being made on my behalf. The continuance I did not know about. The waiver of appearance I did not know about. Uh, the waiver of appearance I did not know about, along with other documents, and I am never sent copies of anything filed. So I know I keep trying to tell him about with no response. Further, the already massive dysfunction in my 4-year case. I was hoping in the PTC status hearing on Tuesday, January 16th, I could at least play catch up in the courtroom for 5 minutes so many of my attorneys have done prior. See, she didn't even change her. It should have said for the catch up in the courtroom for 5 minutes, period. Which so many of my attorneys have done prior, is what she's trying to say, including Mr. Hobson. In the one court date I had for a continuance to express and emphasize the need for him to communicate and schedule a second very overdue meeting. I still have not even heard from Mr. Hobson about our missed PTC status hearing. What's the status to date? Oh, hang on, I'm about to cough. I apologize. Oh, thank you, Just Another Smith. I'll get back to y'all's things in just a second. Hang on. To date, I have had 133 days and counting. Attorney and his client have met. Wait, 1 out of 133 days that she's met with him, she's saying. To date, 3 out of now 3,192 hours. Attorney and client have discussed partial general case information. What does she expect? I mean, really, what does she expect, y'all? Can you see her? Can you guys see her? I picture her sitting in her cell, and she's got all 5 of her hands held up, right? And she's counting, she's using her fingers. She's got all both of her hands held up, and she's got all 10 of her fingers up, and she's like, finger 1, 2, 3, counting the hours. How many hours in a day? How many days in a week? How many weeks in a month? Can you? I can just see her doing that. Y'all know she's got her own little calendar. To date, I still have not seen my discovery. Your Honor, when is the next status hearing, please? Especially since we were not at the last PTC status hearing. We? Is she saying we as in, does she have another personality, you think? And especially since I am now trying to communicate with my attorney in more than one way, I fully maximize and utilize the minute amount of time allotted before trial, my fair, appropriate, lawful trial. I still am wondering why, though. I've had to wait for 4 years for something to finally happen on or in my case. Ask Judge Wooten. Oh, I'm sure he has. I wonder also, was I the oldest case on this docket? Probably, Sarah. Either way, I'm still here, waiting patiently and very excited to get this highly anticipated show on the road. I await your overdue and very needed judicial direction, supervision, and intervention. Thank you in advance, Judge Kranick. Welcome. Oh, just welcome, period. Welcome to the shit show. Sincerely, Sarah Boone. And then, of course, I just went over that other stuff that she did already. Crazy hooker. All right, let's go back to these letters, you guys. All right, so he referenced the August the 26th and the August 30th. She'll write in blood on toilet paper. Charlotte. That is awful, but I love it. Oh, okay. All right. Let's go back and look at these letters real quick. Let me pull them up on the share screen. Because oh, you guys, if you've already seen these, I apologize, but there's honestly been so many damn letters that I just don't even freaking remember which ones I've read and which ones I have not. So I think this is the 26th. 100 more days of no communication. She's writing this to the judge. She should have put honorable in front of judge, but okay. How do you feel about your attorney withdrawing? Question mark. Oh, now she's throwing like a shade at him. She just threw shade at the judge. That is not smart. During an attempted video visit by a misrepresented shifty reporter, this is how I was made aware of my attorney, Frank J. Bankowitz, cowardly and for the second time trying to ungracefully bow out of my case. So apparently she was mad the first time, hates him. He's not doing what she's asked him to do, but now he's trying to bow out. She's mad about that. I don't understand that. Mr. Matt Johnson, please honor the integrity and ethics of a real reporter and not camouflage yourself as my friend in order to push your way through the rules and regulations of their correctional facility. Well, you go, Matt Johnson, because apparently Matt Johnson got the scoop. Professional is also an option when scheduling but clearly does not pertain to you. Just don't schedule at all, as sorry guys, I have nothing to report to you on or court TV altogether. You're not even a real news channel and only add to the confusion and hysterics wrongfully, illegally, and inappropriately concocted in my case. Do not contact me. Matt. Sorry about that, buddy. Okay. She says this is her perspective. I am surprised my attorney is trying to yet again to give up completely. No, it is a blessing. Question mark. Yes, let's be honest. Frank J. Bankwoods is a dud of an attorney. He's an unprofessional. He is unprofessional, hides, lies, and is disrespectful. I had a feeling when other attorneys spoke about him that she might be referring to her first 5 attorneys. I don't know, but she says I had a feeling when other attorneys spoke about him, winced, sighed, or rolled eyes, saying they have some of his clients. And after finding his oh, I don't even know if I want to read this, y'all. That's 3 public reprimands I announced to the court in which he said pissed him off, being the reason for his first attempt with drawing. This was going to be an adventure, but nonetheless hoped for the best. Unfortunately, I seem to have gotten the worst. Thankfully, there are many other professionals and scrupulous, valiant attorneys still available. Well, honey, you are running out of them. I mean, there's only so many in Florida. You know what I'm saying? Like, it just, and somebody else here, let me jump back to the chat. Somebody else here made a very, very good point about this. How many times can she do this? How many times can they allow her to get a new attorney because the attorney just cannot please her or is or isn't up to her standards? Barbara says, "Who wants to be Sarah's pen pal?" We should write her. We should write her. Y'all want to write her in jail? We'll do it. We'll type up a letter all together on our own and then send it to her. Okay. All right. Let's see. After all my previous letters and 6 withdrawals to date by my choice, not by my choice, not by her choice, Judge Wooten, you will remove the blindfold this time when throwing your darts of justice at the everyone has constitutional rights and should be treated fairly. Dartboard. Oh, girl. And you wear glasses, so let's go for the bullseye. Please, thank you in advance for hopefully carrying this time. What? What is she like, is she self-sabotaging? What the hell? And we know she's writing this, she's sober now, or well, she's supposed to be. She could be drinking, like, hairspray or something at this point, there's no telling. Alright, also, if you're insistent on continuing to be my judge and resolution is supposed to be every 2 years, I'm going 4 now, and you've stated to me in your court previously I have not because I asked not. May you please observe and act independently as a judge and utilize your judicial authority to judicially maintain forward direction on proper, lawful, ethical treatment and respect of the client in any case. Effective communication between all parties, especially the client and attorney, is being made. I mean, there's no periods in the sentence, you guys. Productive, regular progress is being achieved, and all around fairness of and in every aspect is constant. It's kind of like Brooks, having just being clueless to the fact that this judge has a lot more power than she thinks he does. Aren't you tired of getting my letters? Well, yeah. Always asking about the same questions, concerns, and drab information? Yeah. Please do not ignore and avoid what I have to say any longer, as I am sure the taxpayers are unapproving of their tax dollars, mine too, being wasted for all my attorneys. You keep blundering. It took almost 14 months before my I told you so moment with Bankowitz and all of my other attorneys, 42 months total. See, that's the other thing too. It's like, so now they would have actually made a huge step today if she'd have kept him on board. If she'd have just kept her mouth shut and let him do his thing, she would have been able to go ahead and get that scheduled. They would have set the next pretrial, which probably would have been next week because there was another hearing scheduled for next week, and we were on schedule to actually go to trial on October the 2nd. So she's like, what? Please, I think she really thinks she's gonna get off on this, y'all. She's gonna get away with it. She thinks she's gonna get away with this. Please also see finally the absolute unfairness, fabrications, impediments, illegalities, and dysfunctions ongoing in my case, and how truly unmistakably ransacked by the justice system and perverted by the whole world my entire case has been and become, and yourself also, to the mayhem, hype, and added difficulties. Girl, all these letters that you're writing, they're adding fire to all of this. I have an unfair opportunity in everything with all the predisposed, non permissive, illegally distributed, case altering, sensitive information and details spread globally for everyone's viewing except me. My hand is known before the cards are even out of the box. There's not a bell anywhere that hasn't already been rung for all to hear. Seeds have been planted, all illegally and unfairly. For the momentum amount of time allowing for the monumental I can't read this morning. For the monumental amount of time allowing the world to abuse and devastate my private case information, lack of proper orders, not having an appropriate attorney, and non existent security and protection of any kind for all said information becoming so easily accessible, mutated, and shared without my permission and before my trial, it is unfair and unlawful that a heavily prejudiced, ignorant, incorrect prejudgment has been made as a result. This could have been stopped, lessened, or averted if someone was doing their job correctly. Still doing mine by telling you I am not. No, I still believe. No, still I believe it all depends on how much money, notoriety, and benefits anyone and everyone can get for themselves, and however, no matter the destruction caused on the omnious, irreputable shadow made along the very lucrative way, a system for all the wrong reasons. They need to take our dictionary away. Okay. As for Bankowitz and his irreconcilable differences, this means because I asked again about his phantom phone numbers and any progress occurring since not speaking to him in months. And after, oh Lord, 408 days, 58 weeks plus 9,792 hours of his representation from the date of appointment 7/11/22 to withdrawal attempting on 8/22 of 23. Well, he lasted a year, so bless his heart. All right, with only 6 in-person meetings. That's more than I thought she got, actually. Totaling 7 hours out of 9,792 hours. 4 to 15-minute video visits. Oh, I'm sorry, there were 4 15-minute video visits. And 2 phone numbers given, 0 working, 0 calls answered, 10 letters from me, client trying to communicate, no response. 8 letters from me, client to judge, no response, productively. She is so stupid. 4 letters from me to my investigator asking him to attempt communication on my behalf to Bankowitz. 5 known attempts by investigator by himself directly and on my behalf, no response. 9 attempts made by outside sources on my behalf, including phone calls, voicemails, emails, no response. Also, trying to use recycled components in my case. No discovery, witness list, research, orders, order instructions, records dispositions, downloads, etc. after 13 months. So what's she saying? He's picking up where others left off and she doesn't like that? Well, he's not gonna go back and do all that if he doesn't have to. I mean, I guess a good attorney would say, "Okay, I'm gonna take this and we're gonna look at it, and then I'll go back and do my own work of it too, but yeah, we're gonna start from this point right here. We're not gonna start from scratch, Sarah." 11 out of 13 months are with no communication, none, if in any forms. The only difference is I want progress, productivity, honesty, respect, and results. If he were such a professional attorney from the beginning and not selling me on stable of witnesses, historical background, and all his abundant resources, he wouldn't still be avoiding and cowering behind his now second attempt to withdraw. Surprised she didn't throw a stab at him for having a freaking walker. My goodness. Clearly, everyone can see anyone in my slides would be highly unsatisfied with Bankowitz' overall performance as an attorney, and no dedication has been made on his part in my case or any productive progress or effort. What time has been put forth solely the 7 out of 9,792 hours in 13 months. And as I remind And as I reminded Bankowitz during one of 4 video visits and him repeatedly telling me how busy he is with all of his other cases, murder cases, after again, no communication for months, I politely raised my hand to the camera where he could see and said, "Murder case. I am your client also and have been. When do I get to go to trial like all the other clients?" He said he had to think about everything and disconnected. No word since 100 days later, except for the withdrawal I learned about from court TV, not him. That is pretty bad, but, she's bashing him. So it's like, Judge Wooten, with everything I have stated and all my information produced to you in all my previous letters, so you are aware, clearly Bankowitz should not continue being my attorney. Wouldn't you agree? Clearly, you should have listened and reviewed much earlier when I was trying to communicate to you 10 letters ago just about him. So the judge is an idiot, too, or two. Please listen and include me going forward. It is my right. Oh, shit. This is upside down. She probably did that on purpose. With all that being said, and because in the past you have stated to me you have other priorities not allowing me rightful, appropriate time to speak in your courtroom when I am allowed permittance to my meetings and I am on you. What? On your schedule for the day. 4 times going to court with Bankowitz. Total times with all the other attorneys, 3. 7 times in ongoing 4 years. And then she's got this list. Oh, she did all the homework for us. Okay, so let's look at let's look at all these attorneys' withdrawals. Oh, wait, I need to drink something before I read this. And it's non-alcoholic, so just settle down. All right. The first attorney tried to withdraw on April 29th of 2022. Then he tried to withdraw again on May 10th, and he was granted. On December 27th of 2022, her 6th attorney withdrawal was denied. This is Bankowitz. She goes, "I never even knew until he stated it in court during status hearing. No copies received yet." And on May 25th of 2023, on a status hearing, the judge stated I was delaying trial. Me! Hence my letter dated 6/29/23, hand delivered, second copy. Ooh, July 21st, 2023, she says, "Judge stated he has other priorities for the day when I was trying to address the court. Please grant me Frank J. Banks' motion to withdraw as my attorney. I, Sarah Boone, permit Judge C. Wooten to release Frank J. Bankowitz entirely from my case for obvious aforementioned reasons stated." Wait, you guys, do they really need her approval? I will allow withdrawal when it should be termination. Oh, she's saying it should be on the record that I fired him. Yeah, I fired him. What's she hoping for next? Oh, Sarah. In the meantime of the selection of my next attorney, she's going to tell everybody what to do now on this one. Now I want my next attorney to do this, and I want to do that. It needs to go get the dry cleaning, and it needs to go to the grocery store. And okay, and also going forward, please enable and support me in still trying to utilize my constitutional rights. And as a still proud citizen of the United States, oh bless her heart, I just heard the national anthem playing in my head, and stop willingly, actively allowing the violations of said rights. Please include me. Please listen to me. I have what I have to say. It was not intentional. I'm just kidding. I had to throw that out there. That wasn't in the letter. Okay. No one else does or has it. It's my case. It was done by you. It was your suitcase, too. Oh, that was awful. I'm sorry. I'm sorry. I'm being horrible. I just can't help it, you guys. This is ridiculous. This is ridiculous. And you know what, Christina, you might be right. She is a mix of crazy Letitia and Brooks. Yes, and after you're right, Destin. After hearing this letter, he probably said, "You know what? Maybe I'm in the wrong profession. I should try something else now." Oh my word, you guys. I mean, she is just a mess. All right, y'all want me to continue this? Don't finish it. Hopefully, futuristically, why does she keep adding all these big words? Like, it just, yes, Barbara, we need to get her the Black's Dictionary. Hopefully, futuristically, with a better, more appropriate professional attorney of your choosing, less letters, if any, will be generated, and more time you will have to dedicate to all your priorities you made known to me in the past. Please know also, Your Honor, I know I am not priority as you condescendingly and incorrectly stated, nor am I making myself out to be ever or ever have been in anything my entire life. I am a client to my attorney, an inmate in the county jail, and criminal case for your righteous judgment still. You know, y'all ever written a letter to somebody when you were mad and then you were like, you know what, I'm going to set this here, then I'm going to walk away something, or you know what, I might even sleep on it, and then I'm going to come back in the morning and reread with emails before. And then I come back and read it the next day and I'm like, yeah, no. And you're like, well, maybe I'll edit it. And then you go to edit it and you're like, no, no, I'm not doing this. I'm not doing this. And then you just delete the letter altogether or the email altogether. Why doesn't she do that? Why doesn't she do that? Clearly, after yet another letter from me and another withdrawal by my choice, and 42 uneventful months later, still looking for the starting line, and 7 times more, nothing has been made priority. The sad thing is that this thing has gone on for this long, and then I mean, they're gonna find her guilty, like, what who wants to put money on it? Not that we can gamble online, but let's just pretend we could. We'll gamble buttons, let's just say. Who wants to put so many buttons down that says that Sarah, her jury is going to come back within the same day or the following day, just like they did with Brooke, like just really quickly with their judgment that she's guilty? Anybody else want to go out there on a limb and just say that that's going to happen? All right, please help Banquets wipe the sweat from his brow and inform him he can stop the self sabotage. He is no longer my attorney. Amen. My perseverance is real, so is my truth. I can't wait to meet the bullseye. Court appointed. Audacious, aud- audacious gratitude, Sarah Boone. She forgot to put suitcase in there. Suitcase, Sarah Boone. Oh, there's a PS. Wait a minute. Important. Please send me a copy of this letter as the court used to consistently, so I have receipt and know it was received and hopefully read. I do not. Oh, we read it. We got it. It's on YouTube too, Sarah. Just by the way, BTW. I do not have the resources being in jail still to make this needed copy myself, nor the pen ink to rewrite Girl, we thought your pen had already run out of ink, all right? Hopefully, my next letter will be less involved from all the necessary remedies being made. Also, my attorney is really an attorney. Ooh. Thank you in advance for the copy, your caring and precious time. I will look for you in the mail once the copy has been mailed. She is just Oh, here's her address. Here's her address. If y'all want to write her, go ahead. If you're an attorney and you want to represent her, now's your chance to jump in there. Her work. If you don't plan on doing anything else for the next year. Okay, let's see. I'm going to go to this other doc. Now, that was the 26th, right? So we're going to share this tab. This is, excuse me, let me clear my throat. All right, so this is August 30th. So 4 days later, she writes again, Clerk of Court. Oh, wait, sorry. Sorry, I had another tab open. Okay. Oh, gosh, this is awful. Clerk of Courts, Judge Wooten, anyone. So confused! Exclamation mark. So tired of the perpetual question marks over my head. As usual, thanks to the ongoing convolution of everything from my no communication, no system, not including me, and no care. And I can't ask my attorney because he's trying to withdraw again. I wouldn't get a response anyway. It's funny how the only piece of correspondence via mail I have actually received from Bankowitz is his motion to withdraw as counsel. Judge Wooten, please clarify. My requested information is if my case can prepare and be planned and plan accordingly. What is going on? This information in question is all I have from an outside source looking on the clerk's website to keep me updated since no one else will. You can watch my channel too, girl. Okay, I've tried to dilute some of the question marks, but need you, Judge Wooten, to help me get it correct and begin my preparation. Please clarify and send copies for. And then she's, oh, Lord. Girl. So I wonder if she thinks she's going to have to be her own attorney when she wrote this. She was scared they weren't going to appoint somebody else again. And this is just all her little notes here. Oh, good gracious. Again, what is going on and when? I rarely am included in the certificate of service for any document filed. I should be an automatic inclusion. Please send revised and all correct copies of the aforementioned documents so I have for my records and the only way I know, unless able to find an outside source. Again, receiving copies of notifications, updates, schedules, everything to all my meetings, conferences should be automatic so I know it is my right. Please include, finally. And again, she's just like Brooks. She wants a freaking secretary. Am I really the only one who is trying to figure anything out for and about my case to finally conclude? Shouldn't I, the defendant of all parties in my case, be included overall and receive necessary needed copies? Please clarify everything. Sarah Boone. And that's that. Whew. Y'all still with me? Well, hello, my friends. I'm just going to give you fair warning. You might want to grab a pack of Junior Mints, I don't know, some popcorn, some Cheeto Puffs, and a soda, whatever your vice may be when it comes to good snack food. Because I'm going to tell you right now, what I'm about to deliver you guys is so fattening. It's insane. I cannot believe. Okay, first, let me start off with this. On my June 13th video of Sarah Boone, it was entitled, Will Attorney Number 8 Be Set Free? This was my thumbnail. So when I saw the latest letter that was dated July 18th, I about fell on the floor. Oh, if you don't know what I'm talking about, let me show you now. In this letter that she wrote to the judge, her life is on the line. She added this little thing that she drew. Let me see if I can give you guys a better view of it. Can you guys believe this? Can you guys believe this? It says, here, I'll read it to you. Inmate seeks attorney. Looking for a this is like a freaking garage sale. This is like something you would do on a we know she does like to do crafts, arts and crafts, right? So this is probably, she probably enjoyed this herself doing this, but it says, looking for a prosperous challenge, ready for your close-up on national television? Are you zealous with a side of keen? Show the world who you are with your original creativity, extraordinary expertise, confident ingenuity. Qualifications must include being trustworthy, honest, passion-driven, open-minded, exceptional problem-solving skills, client inclusion at all times, team orientation, collaboration, extreme efficiency in listening, communicating, understanding, dedication to success, possessing a winning mindset, capable of excellence in representation, committed, maintaining faith in the client and case with the ability to think differently, overcome all circumstances. Epic opportunity awaits. Sarah Boone, number 205623, Orange County Corrections Department. Invest in the oppressed. Believe. I'm just sitting here shaking my head. I probably should go on screen for this one. I really should go on screen for this one because you guys could probably, appreciate the look on my face right now. July 8th, 2024. Honorable Judge Michael Kranek. I want to note that this was done July 8th, but it wasn't put on the file, or wasn't scanned until July 18th. Now, just to give you guys a background, it was actually on June the 28th when she was told that she would be representing herself. So I'll give her a little bit of credit in saying that, let's see, how many days was that? Was that 2 weeks? That's not 2 weeks, is it? It's over a week. It's over a week, under 2 weeks that she did this, okay? We all know she has no patience with anyone that she comes in contact with. Dear Judge Kranek, where's my discovery? I'm still waiting for you to provide me with the contents of what former attorney Cashman supplied to you and the court at the surprise hearing held in secret on June the 28th of 2024 at 1:30 p.m. It was a surprise hearing that was held in secret. So was she not there? Wait a minute. Let me go back over here and check the court docket. Per the court, comment, the court made findings that the defendant no later. Court minutes. Oh, she's so full of shit. You guys, court minutes say that that the comments are, the court addressed Attorney Cashman's motion to withdraw. The defendant was placed under oath. The court read on the record its order on 6/28 of 2024 as it relates to motion to withdraw to the defendant in open court. The defendant gave a statement and asked questions of the court of his order. The defendant was provided a copy of the court's order and hand delivered on 6/28. She was right there. She was in the courtroom. You crazy hooker. Okay. Whew. Let's get back to this letter. Your designated clock of unfair judgment ticks empty and incessantly while waiting for you to deliver. As usual, it's in your favor. In your nonchalant, relaxed, unconcerned attitude of me to receive, you are robbing me of precious, life-saving time to fully and properly defend myself on top of my already and all being violated constitutional rights and being forced to represent myself based on false information. Okay, we know her voice is annoying, so I'm going to stop talking like that. I'm going to go back to myself because even though mine might be a little less annoying than hers, though, I will say that much. Okay. I do not even know what is contained in said discovery after being withheld from seeing all to date and for the first time in said surprise status hearing, along with my supposed digital evidence being produced by Cashman finally after never being shown any during her representation. And again, I do apologize if I'm running together, you guys, but as you can see, she does not know when to punctuate. Her response to me when I was asked to review this was, "Your first attorney said he reviewed it with you." That was forever ago. That was like 4 years ago and 7 attorneys ago. You're my attorney now. And no, I did not. This is what I had to deal with. I have not seen it in its entirety and completely to date. Please note, I do not have access to a computer to view these materials. I'm doing my very best to figure this out, everything else out, as I go in my newly unwanted, wait, oh, my newly unwanted forced position of pro se. Please do not penalize me even greater than being already. I'm trying. Somebody needs to take that pen away. Seriously, somebody needs to take her pen away. She can't even help her. I mean, does she not realize this judge, her life is in his hands? And honestly, do you think any attorney out there is going to jump on this now and be like, I want to step in and help because I want to get the only way I see that happening, and I think I've said this before, is if some attorney out there is desperate enough to where he wants to be seen in court, that he would do this. That he's like, okay, I'll take your case. You know, one thing I noticed on her little post of her job wanted post, she didn't have any money recognized there. There was no money. I guess that's what she meant by publicity, though. Her national attention, international attention. I mean, because he might work in Korea at some point. You never know. Okay, so then she says, please know also I'm in an open bay dorm living with 63 other inmates. Oh, it's an open bay dorm. You know what I think of when I hear that? Have you guys ever seen the orange? What is Orange is the New Black? Black is the New Orange. No, Orange is the New Black. Is that the one? You know how they had open bay? I guess that's what she's in. I need to figure out how to view anything securely to avoid further exploitation and mean ignorance. There is no privacy or individual access in jail. She's obviously familiar with YouTube. She's obviously familiar that there's people out here in YouTube land that are already on all this stuff. She's mentioned it in her past letters. Maybe she's just being told this from people out on the outside. But if she doesn't want people to exploit her, then maybe she should just stop writing freaking letters. Cashman Dash, I'm glad I could help you shine in the courtroom in front of the judge by you professionally and finally bringing everything I've been asking for since day one and after I included you on my letter to the judge ensuring return, unlike you who did not include me on your motion to withdraw. Surprise! And had to find out from someone else. And 3 days before this, surprise, status hearing. So you would even know what to bring. Why didn't you bring to any of your 20 hours of meetings with me? As always, it's in everyone else's favor but mine. So I guess she thinks Cashman's going to read this, which she probably will, I don't know. Cashman's probably somewhere still drunk over getting away from Sarah at this point. She probably took a vacation at a far off island somewhere, and she's drinking cocktails with umbrellas in them. How much real time will I have to prepare and properly, especially you know how much time you've got. You've already been told this. Especially the fact you have me doing everything while incarcerated. Oh, okay. Okay. I'm sorry, Sarah. We're going to let you out. We're going to let you out while you prepare for your trial. How about that? What were we thinking? What were you thinking, Judge? You forgot to unlock her cell before you told her that she was pro se. What happens when more time must be utilized to discover where my lost discovery is? I've been asking for repeatedly. For depositions to locate my witnesses, contact anyone via collect phone calls. That's a real hurdle. Wait to receive transcripts, any records, everything I need to finally build my defense. Or is it your plan, Your Honor, to just leave me out to dry and in a hurricane? Okay. I'm going to pause there for a second. I have a thought that if they make her represent herself, that any appellate attorney could crush this. However, I don't see, it's like their hands are tied. What happens, guys, if nobody else steps up to take this case? Are we going to see her in the courtroom acting the fool? Like, I honestly don't think, I think she's going to be whiny. I think she's going to be very whiny. She's going to be very needy. It's just, it's not going to be fun to watch. It's not going to be her being all gung ho about representing herself. I really don't think that. So and then I think about how, you know, as I've said in previous videos, it's all about the defendant's rights. It's never about the victim's rights. The defendant gets more rights than the dang victim does. And somebody's going to look at this and say, you can't allow her to represent herself. She doesn't have a clue. She's not, I want to say, like, and I'm not trying to sound mean when I say this or be funny. She is not smart enough to do this. She's not bright enough to do this. I'm not saying that I could get up and defend myself, but I just think I'm a couple of notches higher on the knowledge ladder than Sarah is. And I definitely know how to read a room a lot better than she does. Okay. Your time constraints are extreme and unreasonable. Your decision you claim to have considered from your order is illogical and unfair, specifically that it has been malformed by your ignorance and experience of my case. Well, you've called him everything else. Why not call him ignorant? Misinterpretations, straight lies from the attorneys appointed. They are brazen to stand at your pulpit in your courtroom and commit perjury to your face and the world. But yet, it's me. It is my belief, and from your order, that actions speak louder than words. The court is sabotaging me, forcing me, pressuring me, setting me up for failure. If any of the prior attorneys would have included collaborative, I think she meant collaboration, during their time of representation, you not being brainwashed and partial from believing everyone over me and implementing your intrinsically misconstrued, unfair order formulated from, I would not be writing yet another letter, would I? She talks to him like he's a child. Can you imagine? Okay, then the soap opera continues, because in the meantime, while your clock ticks ceaselessly, and loud as I was for your delivery to anything, even more fingers are noticed. They really do point back. And I'm defending myself against your, what is that word? Libellus? I can write letters too. Yeah, we know that. Oh, I can write letters to order. Please, would you post my included document in your break room? Can you put this up in the break room, Judge? You don't mind, do you? I think it's time to pop a beer or a bottle of wine. I don't know. Oh my gosh. Wherever you think it may be seen and understood, unlike me in your courtroom. Or, Judge, if you know like a little breakfast spot that a lot of attorneys meet at, or luncheon, maybe you could just, make copies of it for me and stick it on the outside of the glass door when when you enter the restaurant. Can you imagine? Can you imagine if these were all over town? Somebody, if you're in Orlando, please call me. I need you to go check this out. I need to know. First of all, I would think that he doesn't share a break room with attorneys. He only would share, I'm pretty sure judges don't share break rooms. I'm pretty sure in the courtroom or in the courthouse, it's not set up like a normal job where, everybody meets in the break room to go eat, because there's laws, Sarah. See, the attorneys aren't allowed to speak to the judges unless the other attorneys are present. So they're not going to put them all in a break room together. It's not a hospital where they all go have lunch in the cafeteria. What the freak is on this woman's mind? Like, what? Somebody help. Somebody help me. I don't even know. I'm without words at this point. How about by the copy machine? Is she saying where your JAs, junior attorneys, should have made me? The news crews, court TV, professional YouTubers, photographers, the world, a copy of the notice of hearing where all aforementioned improprieties occur. Oh, and then some, including the drop off of my case materials, said order being ordered, and me being pulled by my uniform to exit your courtroom while still trying to speak and defend myself. Oh, I would have loved to have seen that, y'all. Oh, I would have loved to have seen that. Can you imagine? That's why they did it, so the media couldn't be there. She said it was in secret, and honestly, we did not know they were going into court that day. It was not on the docket. They did that so that no media would be present because they knew she was going to throw a hissy fit into a courtroom and they were not going to let anybody see it. I guarantee you. I guarantee it. So let me start over with this. While I was being pulled by my uniform to exit your courtroom while still trying to speak and defend myself against all the mayhem and chaos, especially the surprise of even being there unprepared and without notice. That was a question, I guess. Oh, wait. My posting and everything supposedly is public record, and there is no notice at all. There wasn't. It's in your favor moment. It's a group effort. It's saboteurs. They're saboteurs. Surprise! I shall return. Nothing is impossible. Believe, hopeful, grateful, awaiting. Thank you for posting. Sarah Boone. Number 20005623 FDC-B4. Remember, please, Judge Kranick, fair, neutral, impartial, you must be always. I can do all things through Christ who strengthens me. Philippians 4:13. I always laugh when the people that commit heinous crimes refer to the Bible while they're still, so new at, well, it's been 4 years, but I really don't think Sarah's following the Bible and all of the hate that she's spewing onto these pages that she's writing to these people. Invest in the oppressed. Girl.
I've been here for 4 years and I'm tired of being here and I'm tired of going through all of these attorneys, which are not my fault. But when 100 days have passed and I haven't heard or said or done anything other than try to figure out where you are because your phone doesn't work, I'm not a bad person because of that.
See, that's what we're going to get. If she goes to court for herself, that's exactly what we're going to get. Just that. That whiny voice. And it'll probably take at least 2-3 weeks to have the trial because of her not having the knowledge. Surely, somebody's going to step up to help her. And I'm not saying that she should be given the help. I'm not saying that at all. She shot herself in the foot. She's where she is because of what her actions. First, her actions, getting herself there, number one. Let's forget. Because she doesn't take any responsibility for the fact that the reason she's there is because of her actions got her there. What she did to George got her there. Secondly, she takes no responsibility whatsoever that all the letters that she's written, 8 attorneys, you guys. I'm sorry if I'm getting loud. 8 attorneys. But it's not her. She truly still believes in her mind that it's them, not her. This woman is freaking delusional. This woman is going to tear down the judicial system. Oh, Lord have mercy. I want to hear your input. I want to know what you guys think. This is the most insane thing I've ever seen in my life. I want to know what other attorneys are saying in their break groups. Not in their break groups. I'm just kidding. In their other law offices in the area. Because, I guess you don't even have to be in the area. This is all pretty national. Oh, even in Korea. What are those law offices in Korea talking about? Hey, Boonies. Well, Sarah truly is the gift that keeps on giving, Clark, because they've uploaded what she sent to the court on these 2 motions. And of course, she couldn't just do the motions. She had to put her 2 cents on at the end of them. So we're going to read those today. And do you guys remember previously I'd said there was a 2-page document that had been uploaded to the docket and it was locked? Well, they've unlocked it. So we're going to do that one first. Oh, Sarah. You're such a pain in the ass. Oh, God, this poor judge. Again, can we just take a moment, have a moment of silence for the prosecutor in the case? Seriously, you guys. I mean, I'm sorry. I'm not trying to make fun of the fact that someone lost their life. It's like, this is just freaking ridiculous, okay? All right, let's get to this. Okay, August 1st, she writes it to Judge Cranick. Judge Cranick, I am unclear how the court had my correct address prior to you forfeiting my right to counsel, 6th constitutional amendment, and forcing me to become pro se, and now does not. All my pertinent correspondence being delayed in my receipt of due to the court's error of sending to the wrong address now. This deters my fair and proper notice and any preparation required. Please correct immediately. Please also forward to whomever, change in portals, and correct in all correspondence tags or lists I am attached to and included in by this notice. I am expected no further hindrance or difficulties in this matter from the court's immediate attention and understanding of the importance to receive all correspondence timely and appropriately. You like how she puts my address as follows? Exactly. God, this woman needs some emojis for her handwritten stuff. Maybe she'll start drawing some emojis. Oh, and by the way, you guys, if you'd like to send Sarah a letter in jail, here's her address right here. Thank you for your cooperation. No more deterrence, please. The court is appreciated. Thank you, Sarah Boone. Pro se, indigent defendant. Oh, I'm going to do a video, you guys, specifically on just the jabs that she makes towards the judge. Oh, good gracious. All right, hang on. I need my lip balm for this one. Let's go over this other one. This is a motion that she did. Now, this is a 10-page motion, which they went over this in court already. She wants hard copies of the discovery submitted to the court by a former attorney for preparation of trial in her criminal case. Discovery definition, box A and B. The court will reach out to the jail to inquire how to deliver to the defendant and will provide written order to release both boxes. These two boxes, A, B, are the defendant's original discovery she has not seen in full to the present date, and it is her right to receive by law to fairly proceed in her defense. She wants to be able to inspect, copy, test, and photograph the following information: any tangible papers or objects that were obtained or belong to the defendant, sanctions, willful violation by counsel or party not represented by counsel of an applicable discovery rule. I'm not going to read all this, y'all. This is all her basically copying out the legal things to make this motion fly, so to speak. Now, here she jumps in. Not unreasonable or unduly burdensome or expensive, given the need of the case and the importance of the issues at stake in the litigation. She's basically saying the government is obligated under the Brady Law to disclose information in its sole purpose that is material to the issue of guilt or innocence. The government places heavy reliance on the cases that hold information as material if there is reasonable probability that, had the evidence/discovery been disclosed to the defense, the result of the proceedings would have been different. She's getting ready for her appeal, y'all. Any documents or requests made intentionally unavailable to the defendant through discovery in the federal rules of criminal procedure are in direct violation of the defendant's due process with prejudice and shall not be denied, restricted, or deferred upon request by the defendant. By doing so, this constitutes an intentional misconduct warranting sanctions. By the court only providing digital USB discovery to be viewed solely on the laptop provided by OCCD and restricted to select times during the day only, motion for extended times in process without the necessary hard copies, the defendant is unable to A, review, research, investigate, build her defense at any time, and numerous hours are ineffectual, and wasted by not having access to the laptop and by not having the original hard copies available to use physically during the laptop's closed hours. B. Write notes, remarks, interpretation, explanations, make recordings, and of any kind. She makes a point here that both are available to be provided by the court. Due to the court's error of not communicating with the defendant, foremost to avoid presentation circumstances in the jail prior to the implementation of the order on June 28th and after the defendant's July 8th letter questioning the location of her provised hard copy discovery. Oh my God. She's basically just marking down here, this is what you guys have said you were going to do and you haven't done it yet. She's bitching about the fact she doesn't have her discovery. And she says, it's an obstruction of justice to withhold the defendant's original hard copy discovery that has been compiled for ongoing 5 years to properly, fairly, physically construct her rightful defense at all times necessary to her and on the sole independent decision of the court, as the defendant did not ask or suggest this USB only option, was not included in any decision making, collaboration, or equal agreement for USB only format to be received, and was never advised by the court prior to the implementation of only receiving a USB copies. The defendant was excluded and avoided in this incredibly restrictive decision. More digs at the judge. Time, consideration, and inclusion could and should have been made on the court's behalf to avoid present disadvantaged circumstances, and the defendant would not deprive of her due process and equal opportunities to correctly, fairly represent herself and succeed futuristically. Wherefore, Sarah Boone, pro se indigent defendant, respectfully requests to this honorable court, in conclusion, to lawfully receive, review, utilize the original hard copy discovery, boxes A and B, submitted to the court by former attorney on June 28th for preparation of trial in her criminal case. By receiving the original hard copy discovery in addition to the USB digital copies, the defendant is capable of viewing all discovery information available in continuous preparation of her trial, enhancing her ability to thrive lawfully. She says she can have a success. If she says have a successful outcome, I'm going to scream. Let's see. Enhancing her ability to thrive lawfully in her forced by the court position of pro se and representation of self. Oh, look, she's got a new thing she's added to her little motions, her oath. Her oath. Sarah got an oath. She got an oath of office. You think she got that from Brooks? She might have. I don't know. Certificate of service. She hand delivered it to the court. All right. Let me see what else we want to look at. So that was the 10-page motion. Then there's a 4-pager here. Okay, this is the other motion. Oh, this is the one where she just wants the handcuffs taken off. Which, I'm honestly, guys, I don't see the problem here. It's little Sarah. They can't discriminate in any way on this case, obviously. But I think if she's going to have to sit there and write notes and all that and pass papers back and forth, they need to uncuff her. And please don't get mad at me for saying that. We want this woman, think about this, guys. We want this woman to have a fair trial. We want her to stay in jail where she belongs. It'd be funny. I just had a thought. This wouldn't be funny, but then again, it would be funny. Okay, what if something happens and Sarah gets, let's just say, this would not be funny, but what if something happens and God forbid the case gets dismissed or something? The funny part in that would be that Hooker had to spend over 4 years in jail up until that point. Let me find my notes. Yeah, 4 years and 5 months so far in jail. Now that would be some justice on top of some injustice. But God forbid, let's hope that does not occur. I just don't know why these horrible thoughts come into my head sometimes. All right, let's see. She's basically just saying, she keeps referring to herself as a pro se indigent defendant. Do y'all think that she's going to read this like Brooks did when he started his morning off and the judge asked for them to introduce themselves to the court. She wants to be able to function equally and comfortably while using the courtroom. The defendant must be able to write, reach, turn papers, pick up objects, open documents, pass information, and utilize laptop, all normal movements of the defendant's hands and as a whole to freely, properly, successfully accomplish any task needed for the following. Okay, you know what I just thought about? The judge could have brought this up earlier. I mean, but at the same time, I'm surprised nobody brought this up earlier. But I guess this is only what, the second meeting they've had since she's been an indigent pro se. I say that with air quotes. Prior to the entrance of the courtroom, the defendant is thoroughly inspected and searched, is under direct surveillance of the judge, all judicial assistants, news cameras and their operators, photographers, general public witnesses of the court, as well as vigilant armed duties, also in attendance, greatly diminishing all possible risk of flight or harm by the defendant while unshackled, unhandcuffed. The defendant is simply requesting equal, comfortable, functional movement to achieve advancement in her forfeited right to counsel by the court, which will greatly enhance the productivity and progress for the defendant and the compilation of her defense in her criminal case in preparation for trial. The court's overall perspective and court understanding of this performance obstacle for the defendant is also requested respectfully, seeing her good faith, determined efforts to thrive and achieve in her criminal case rightfully, properly, and fairly. Wherefore, Sarah Boone, pro se indigent defendant, respectfully requests to this honorable court, in conclusion, be unshackled, unhandcuffed, and allowed reasonable freedom in movement to function equally, accordingly, and comfortably in the courtroom. Ooh, now she's added a certificate of service. Girl, she's reading up on all this law stuff. She's starting to add everything. Before you know it, she's going to be a pro. I want to read what else they put. Okay. Hang on. Oh, wait. Okay. You remember earlier where I said there was 2 locked documents? Let me share this tab with you guys. So this is still locked. So this is not the same thing as what she did up here. They just did a delivery of digital copies. Y'all, I'll read this to you guys really quick. We got time. All right, so the court minutes, status held, the court addressed several of the defendant's motions and set deadlines as it relates to exhibits and witness lists. The court will prepare specific order with all deadline dates as what was stated on the record, including the cost for JACs. The court provided the defendant in open court a copy of the email dated 7/24 from Gina M. Giovanni, Captain Security Operations, and a copy of today's order setting hearing. Court witnesses sworn and testified: Christian Lake with JAC's investigator Billy Lane, representative from Prison Break Investigation Sergeant Donald Casey, representative from Orange County Jail. And then up here above that it says, the court advised investigator Billy Lane, representative from Prison Break Investigations, to release the thumb drive to Sergeant Donald Casey, representative from the Orange County Jail, in open court. Investigator Billy Lane also released the 2 boxes of discovery back to the clerk in open court. Defendant requested that the 2 boxes of discovery be released back to investigator Billy Lane. The court granted that. The clerk released the 2 boxes of discovery back to investigator Billy Lane in open court, and trial remains as previously said. So somebody was asking me about what's going on for Friday. Wait, hang on. And then they just did these motions for them. I'll open this. I've already gone over this, but I'll do it again. You know, JAC upped from $5,000 to $10,000 for the private investigator. They gave him $1,000 to incur for, or they are authorizing $1,000 cost for his travel expenses. He's got a service rate of $50 per hour. If the defendant is convicted, the court is responsible for determining the amount of obligation to be imposed as a lien against the defendant for these payments. I like it. Then, this is the scheduling order and notice of all the hearings. So they've moved this trial case management from September 24th to the 26th. And the trial shall be held in this matter for the 3-week period. 3 weeks. They're giving it 3 weeks. Commencing October the 7th. No later than September 3rd, the state shall file with the court and provide a copy of the defendant's state exhibit list and witness list. Oh, that's right. And then they gave her till the 17th to get her exhibits and witness list. It says that the state's digital evidence will be reviewed with the state's investigator, the defendant, and the defendant's investigator no later than September 3rd. This evidence viewing can be done in advance of the September 3rd deadline. The state shall provide defendant a USB drive of the state's digital evidence at the evidence viewing. If this evidence viewing is completed prior to September 3rd deadline, the state shall file a notice indicating the date and location of the evidence viewing with the court and provide a copy to the defendant. So basically what happened there, if you guys did not watch the last video, the DA's investigator, that's right? Wasn't that who that was? Basically saying that, look, if I'm in there and then you have the prosecutor in there, you have witnesses of the court there, and we can make any kind of records that we need to make. And then also, I think it would be a good idea for them to also have Mr. Lane from the defense investigation there as well at that same time. And then they can put something on the record of what went on during that thing, and they can avoid the media. Again, I want them to avoid the media when they're doing this. I don't want them to do this in open court with a camera listening in. I want this to be a fair trial. I want her to go down. Okay, so that's the discovery they're discussing. But the physical evidence, so I guess physical property evidence that they have in the evidence room will be reviewed with the state and the defendant on September 3rd at 9 a.m. Oh my. Lions and tigers and bears. Let's see. September 3rd. I did not write it down on my calendar. All right, September 3rd. Okay, Sarah. If they show it, of course I'm going to have it on my channel. I don't want them to show it, though, obviously. 9 a.m. is 8 a.m. my time, because that would be Eastern Standard Time, so 8 a.m. Central Standard Time. But they're saying they're going to do it in the courtroom. The defendant shall provide to the court any and all written objections to the state's exhibits, including the state's digital and physical exhibits, no later than the 17th of September. And then, of course, like I said before, they've moved the September 24th trial to September 26th. And it says no later than 14 days after viewing the state's digital evidence, the defendant shall provide to the court a written exhibit list identifying any and all digital exhibits that the defendant may seek to use at trial. But they will allow her to extend that deadline if she shows a good cause. Which she'll have so many excuses. Well, I don't know how I'm supposed to do this if you can't. Like, I only have 15 minutes per call. And then it's a fee charge when they call out. I have to ask somebody to help me with the fee. I mean, my ex-husband doesn't have anything to do with me anymore. He's taken my son. They've rode off into the sunset together. And you, Judge Cranick, you have ruined my life. I am an indigent, and now I am pro se. I just want you to understand that. I just want you to feel what I am feeling right now. Before this trial begins, I want to give everybody a serious warning. You may want to go out and buy one of those blow-up clowns that you get at the toy store. You know, the punching clowns. Or a punching bag. You could buy a punching bag. It's just a lot more expensive, and you might hurt yourself if you're not used to it. So I said like the punching clown because, you can kick it and you can, I'm just saying. I might go get me one. You might can find them on Amazon. If I see one on Amazon, I'll do a product placement for you guys. So then after she does that, the state has to review her physical evidence no later than the 26th September. The defendant shall provide to the court the defendant's witness list identifying the names. Okay, I already talked about that. Okay. On August the 14th, this is the part where, and I just said something to someone in the chat about this in the comments because we were talking about whether or not this was a necessary hearing. Let's go down to August 9th since it's coming up first. That's Friday. That's tomorrow. Hello? On August 9th of 2024, 8:45 a.m. Eastern Standard Time, a hearing shall be had in the courtroom on the defendant's motion for the defendant's reasonable freedom of movement in the courtroom, blah, 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 blah. I don't know. I was thinking it was if necessary, but it sounds like they may want to put it on the record what the jail wants to do about her being shackled. And I keep thinking back, I'm like, wait a minute. Giovanni's on vacation until Monday. Wouldn't Giovanni need to be part of that? But I guess they might send Sergeant Casey in the place of Giovanni. So that sounds like they're going to definitely have that hearing. The one on the 14th is the one which is next Wednesday, which would be the one, if necessary, to discuss her motion to lawfully receive, review, utilize the hard copy discovery submitted to the court for preparation of her trial in her criminal case hand filed on August 5th. So, I don't know. I watched this trial. I commentated on it, and I still don't know. See, I'm as bad as Sarah Boone trying to learn all this stuff. They go over the contacts involved with the protocol addressed by the court on July the 25th and provided to the defendant RS as follows. The court further orders that every Monday at 9 a.m., commencing August the 12th, a representative from the Orange County Jail shall email all notebook entries in the IMS from the prior week. Now, when the IMS is, I guess, for every issuance of the laptop. Oh, I love it. How did I miss this when they were talking? I love this. Every Monday at 9 a.m., the court has to be notified and sent the sign in and sign out. That's what I'm thinking it is. It's like a sign in and sign out every time Sarah gets on the laptop and uses the USB device. I love it. That's awesome. Okay. I'm glad we looked at that. Thank you, Judge Kranick, for keeping everything so streamlined and organized and just easy to read. Certificate of mailing. This is where it was sent to her. Okay. Let's see what else. Hold on. Did we look at this one? Oh, this is her address correction. Let me pull this up. So she's like, y'all need to check, y'all need to fix my address. And again, she says Sarah Boone, pro se, indigent defendant. The defendant is unclear how the court had the correct address prior to the forfeiture of her counsel. Oh, now she's saying, see, here she goes, victim. She's a victim. She might as well call herself, at this point, a sovereign citizen. She's starting to spew some of the sovereign language. The defendant is unclear how the court had correct address prior to the forfeiture of her counsel by the court and forced to become pro se and now does not. This incorrect address was not provided to the court by the defendant nor requested ever to be changed. It's a conspiracy, Sarah. All correspondence to the defendant by the court is being delayed in receipt of due to this error, which deters the defendant's real-time response, proper notice, and preparation of any requirement contained therein. The defendant is requesting the court please forward the correct address to all parties affiliated in her criminal case, including all portals, correspondence tags, and all lists the defendants may be attached to by the court. Please also provide all necessary documents for official record of address change to be filed accordingly by the court and in the court. By this motion, the defendant is expecting no further hindrance, difficulties, deterrence in the court's fair and proper correspondence to be delivered to the defendant at the following correct address. So let's make sure we got it right, you guys. Here's Sarah's address. Oh, good Lord. P.S. No. Well, it kind of is. No, it's not. Okay. Please be advised also the defendant mailed by United States Postal Service this information by formal letter to the court on August 1st to emphasize the importance of this immediate correction to be made on the court's behalf and from the court's error. Wherefore, Sarah Boone, pro se indigent defendant, respectfully requests to this honorable court In conclusion, to correct immediately the defendant's delivery mailing address and forward to all parties affiliated in her care. And she lists the statute. The defendant makes the following oath. Oath. I'm just kidding. And even on the freaking postal service, she has to even put her 2 cents in on the freaking outside of the envelope. Really, Sarah? Really? Really?
So I also sent you, I believe, 5 motions. Have you received those?
No, ma'am, I have not.
They were mailed last week.
Then I have not received them yet. The last correspondence I got from you, ma'am, was received on July 8th.
5 motions I've mailed. They're probably sitting wherever else it is, considering it takes a day for you all to receive my mail, considering I'm right down the street from you all. So I have those also in order, which may change whatever information or anything that I'm trying to acquire in between now, the month less that I have in order to prepare for my trial. That's in October. So if you could keep an eye out for those also. I don't think you have enough time. I'm just doing my best. And if you could please keep an eye out for my motions.
I will be on the lookout for them. You said there were 5, correct?
Yeah.
Well, hello, my little boonies. There's been a lot of activity on the Clerk of Court's website this week. It seems like since their last little surprise meeting on 7/25 that the court has stepped up and gotten a lot of things in order here. And it does look like a lot of things have been sent over to Sarah in the last several days. Court is still set for September the 24th, trial management conference, followed by the actual trial to begin on October the 7th. It's really not that far away. We are going to have a hearing on Monday, so we'll be back in the courtroom for that. Until then, let's go over all this correspondence that's been uploaded to the docket. Okay, we'll start with the motions. Okay, so she's basically put together her motions as she's seen prior to how they've been done. And all in all, she's asking for, I'm not going to read all these word by word because it gets there's a lot here. And it's a lot of legal verbiage. We're going to get straight to what she's asking for. She wants money for an investigator. She wants money for standby counsel. She wants money to oppose or acquire witnesses. She wants a proper workspace somewhere at the jail where she can privately work on her case. And she wants phone access because apparently right now they can call out, but it's collect call and they only get like 15 minutes every call. So it makes it difficult for her. And honestly, all this stuff that she's asking for, it's pretty general. It's pretty, she should get these things. I'm pretty certain she should get these things. But here's the way they responded to it. Now, she wrote this prior to them getting together on the 25th of July. And on the 25th of July, she was assigned she was made notice of the investigator who was involved. And God bless that poor man. We're worried about him and how he's going to get through till the next hearing. I wonder how many letters and phone calls she's made to him. So that she got already. Now, what's happened since July 25th is that the court has responded to these motions. And I'll read off their response here. The defendant is seeking authorization for various due process costs as follows: appointment of standby counsel to assist the defendant, costs to take depositions, an unspecified amount for a defense investigator, unspecified expert witnesses to assist the defense, and costs for unspecified witnesses to appear at trial. Oh, she thinks she's just going to pay people to come and appear for her. I didn't realize she put that in there. I guess she doesn't know how to write it all out. Let me see how do I put this? She's over requesting in a sense because she's not really sure how she's supposed to ask for it. She's going to ask for it like in more than one way. All right. So as initial concern, any future request for due process costs, such as requests for transcripts, investigative costs, or experts need to be served on JAC prior to the court considering the matter. The defendant is responsible for providing JAC with any motions for due process costs so that the JAC can respond accordingly to those requests. I do see where this is a little, she's going to be, I bet she is so pissed, you guys, because basically she's like, oh my gosh, I just got all this stuff. I'm trying to read through it. And how do I know what all it's supposed to cost? I'm not sure what it's supposed to cost. How am I supposed to get in touch with these people to find out what they're going to bill me for? It says the JAC may only pay for due process costs pursuant to section blah, 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 blah. And she's probably reading this going, oh, great. Now I have to look up the section 29, 27, and 27 Florida statutes. Number 4, as directed by section 27 Florida statutes and the General Appropriations Act, all due process services are subject to the Florida statutes and the JAC contract policies and procedures. JAC objects to any compensation rate in excess of established rates. Well, where do I find the rates? Nobody's telling me what the rates are. Oh my God, this is so hard. Number 5, standby counsel. As for the appointment of standby counsel, the court entered an order on June the 28th, finding that the defendant waived her right to court-appointed counsel through her conduct in this matter. Thus, the court has already ruled on this issue of appointed counsel. Dang. So they're not even going to give her standby counsel, you guys. Oh, but honestly, I know I get why they're saying that, because she would only abuse the standby counsel. The judge is basically saying, look, no, I mean, normally, yeah, I might, in a normal situation, we would appoint standby counsel, but this is by no means is this case normal. This woman has basically belittled, berated everything about all these previous attorneys. I'm not going to put a standby counsel there for her to abuse. Okay, so then they got the deposition related cost. As for cost to take deposition, the defendant is authorized to incur costs to take depositions for those depositions authorized under the Florida Rules of Criminal Procedures. The notice of taking deposition substitutes for a court order for purposes of the court reporter seeking compensation for appearance fees. As for service of process, service must be through the sheriff unless the sheriff is unable or unavailable to provide service of process. In those instances where private service of process is necessary, a separate motion to incur costs for a private process server will be required. The sheriff must be used to serve in county law enforcement. Okay. As for transcripts, JAC has no objections to regular paid rates. The motion and order for transcripts must reflect sufficient information to identify the proceedings to be transcribed, such as the type and date of hearing, date and type of hearing, and recording type and date of recording. The defendant should only order those transcripts necessary for defense of the case. The unified statewide rates are set forth in the General Appropriations Act. Court reporting services cannot exceed these rates. Well, then, oh my God, how do I find out what the rates are? What am I supposed to do? Oh, this is ridiculous. I'm writing a letter. Who do I talk to? I bet, y'all, she's going to be going back to this poor Mr. Lane, the investigator, and asking him way too many questions, because he's the only person that she can contact right now that has any contact with the court. So she's going to automatically assume that he knows every step that she's supposed to take. And he's probably going to tell her, ma'am, I'm not an attorney. I don't know. I can refer you to somebody that might can help you, but they're going to charge you. I guarantee you, Sarah's already made a phone call to Brian, her ex-husband, and it's like, you need to pay for me to get somebody to help me understand all this. I need somebody who can look at all this stuff and walk me through it so that I can defend myself. I cannot believe they're putting me through this.
I've been here for 4 years and I'm tired of being here and I'm tired of going through all of these attorneys, which are not my fault. But when 100 days have passed and I haven't heard or said or done anything other than try to figure out where you are because your phone doesn't work, I'm not a bad person because of that.
All right, private investigator costs. Pursuant to the uniform statewide rates, the rates of investigators cannot exceed $50 per hour. But she's already been assigned an investigator, so I think This is kind of a moot point, but let's see. As required by Florida law, any private investigator providing services in Florida must have a Class C license from the Department of Agriculture and Consumer Services and be employed by the investigation agency with a Class A license. If the court grants the motion, the order needs to indicate the amount authorized for defense investigator. Based on docket, it appears Prison Break Investigations Billy Lane may have already been appointed to this matter. JAC does not object to the court authorizing $5,000 for a defense investigator and $500 for the investigator to obtain case-related documents and materials on behalf of the defendant. Oh, let's see. What's today? The day's the 1st. All right. So it's been almost a week, or has it been a week, since they went to court. You guys think she's used up that $5,000 yet? Probably. All right. The experts cost. Now, when she says experts, obviously she's talking about expert witnesses. And in her case, where everybody was leaning, they were leaning toward domestic abuse. So it could be that this is where she's going with her defense now, is she's going to have somebody come in and say that she was the victim in all of this. Based on JAC's records, the court previously approved $3,000 at a rate of $200 per hour for a defense mental health expert. JAC does not object to the court continuing this authorization now that the defendant is representing herself. As to other requests for other experts, the defendants will need to file an appropriate motion delineating the following: identity or type of expert, amount authorized for the expert services, and rates authorized for the expert services. Well, how do I know what they're going to charge? I can't believe this is not my fault. I excel at everything I do, and this is just not satisfactory. This is not up to my standards. There's no way that I can figure all this out in time for me to go to court. There's just no way. That's what she's going to be saying. Now that she's gotten all this, in the next hearing on Monday, she's going to be whining about how none of this is fair to her and that she doesn't have enough time. The defendant has the burden to show particularized need for each expert witness. The defendant needs to show the services of the expert is necessary for the defense of the case. As enunciated by the Florida Supreme Court, a party seeking due process cost has the burden to establish 1, the particularized need for due process services, 2, prejudice arising from the denial of due process services. And then they tell her to go look at they reference a case and she's like, oh my God, now I gotta look this up. Where do I find it? I need the library. Take me to the library now. I gotta go to the library. There's like 3 cases here they've shown her. So the time it's going to take her to look these up and read them and understand them is going to be insane. All right. Then it says, the determination of whether to appoint an expert is within the broad discretion of the trial court. An indigent defendant must show the trial court that there exists a reasonable probability both that an expert would be of assistance to the defense and that denial of expert assistance would result in a fundamentally unfair trial. And then there's 2 more cases referenced here. Here's where immediately, this is what I'm thinking. She's going in and she's going to look up these cases. And on her mind, she's thinking, and while I'm in here, I'm going to make side notes about unfair trial. And I'm going to bring up this at some point in time that this is not fair. Them making me defend myself and not allowing me to have an attorney is just, and not giving me more time to find a new attorney. Guarantee you that's what she's saying. Okay, cost of ordinary witnesses. The defendant will need to submit a more detailed motion delineating the witnesses she seeks to summon for trial and the anticipated cost associated with these witnesses. But just a side note, Sarah, you can't pay nobody to say you was innocent, girl. Okay, requirement for JAC due process contract. If any providers desire direct payment, the JAC's procedures require the vendor to execute the appropriate contract and follow JAC's billing and audit procedures to obtain payment. Because of the unusual circumstances presented in this matter, JAC requests participant in the hearing set on August 5th. JAC requests to appear through communications equipment and can be reached toll-free. Oh, Lord, they gave her the phone number. Toll-free at 866-355-7902. Wait, Can she call a toll-free number from jail? Because they still have to accept the call, right? There's still a charge for her to call out. Oh, that's going to be a nightmare. She's already on the phone. Can you imagine? Okay, this is what I have in my head. It's scary what I have in my head, but part of it is Sarah standing at the phones, at the pay phones there in the jail, trying to figure out why, calling this number over and over again, then calling Mr. Lane, then calling Brian and bitching how she can't get anybody to answer. Brian, I need you to call this number and tell them what I'm trying to do. I've got to speak with them. Meanwhile, poor Brian, who did divorce her a while back here, is still stuck with this woman and her problems. All because she was the mother of his child. Okay. Wherefore, the JAC request, should the court grant the defendant's motion, also include in its order the specific due process services authorized, as well as hourly or per unit rates and maximum fees authorized, and that the provider be paid in accordance with rates, terms, and conditions set forth by Florida statutes and the JAC contract, policies, and procedures. All right, so that's the first response. Oh, she is livid. When she read that they weren't going to help give her standby counsel, I bet she flipped her lid. Y'all know. This is not fair. This is not fair. Okay, what was the other document I was going to show you guys? Because there's been several things uploaded. So there's a jail notice here that on July the 24th, in regards to inmate Boone, Gina D. Giovanni, she's the captain of security operations, sent this to lieutenants and sergeants at the FDC security operations, obviously where Sarah is detained. And it says, the above inmate will be representing herself in the case of State versus Sarah Boone. The state attorney's office has been ordered to provide the inmate with discovery to review for court preparation. The laptop is currently secured and will be issued to inmate Boone upon her return from court, August the 5th of 2024. Oh, so I didn't even think about that. She doesn't even have the laptop right now. So at this point, when she gets back into the court on Monday, she will not have had the laptop and had time to, I guess, feel her way through things, look at some of this discovery stuff. So there's going to be even more questions there because of that. It says once the SAO provides the USB, I guess that's once she gets the USB devices to Correctional Sergeant Casey, Transportation Sergeant. So here's what the jail has been instructed to do. Upon receipt of these items, the laptop, charging cable, and USB device will be kept in the FDC main control room when not in use. This next statement is in bold. At no time will the charging cord be placed in the housing unit. Upon the return of the laptop to the FDC main control, the laptop will be placed on the charging cable to ensure it is available for the next day's usage. The laptop and the USB device is to be accounted for with the control room inventory. The control room will make logbook entries for the issuing and returning the USB device and laptop. The dorm officer will make logbook entries for the receiving and returning of these items to the applicable movement officer. A notebook entry will be completed in IMS for every issuance of the laptop and USB device to inmate Boone. What's great about this is that they're going to be tracking her time working on her case, which I think she will. I mean, let's face it, she's going to be in there like a conspiracy theorist trying to go through all this stuff. The laptop and USB device will be available daily to inmate Boone between 800 and 1600 hours, which I know you guys, okay, that's 8 a.m. to 4 p.m. I said it wrong last time. In my last video, I said 8 a.m. to 8 p.m. Okay. This process will commence once all equipment devices have been received August the 5th. Upon receipt of these items, this process will need to be discussed in briefings to minimize any displacements loss of the evidentiary items. Please contact me should you have any questions. Any changes to this process will be communicated in writing. So they're basically just putting it down that, look, we got to follow these rules and guidelines. We have to have accountability on our side that she's getting everything she needs, and we need to log it so that outside of the courtroom, there is some kind of documentation of what's going on here with the discovery items. And also we have to account for this laptop. Okay. The next thing, they have uploaded what they're going to be going over on Monday, August the 5th, in the hearing. And this is their notice to her. We're having a hearing. We've said it in court already, but we're telling you in writing, there's a hearing on August 5th of 2024 at 8:45 a.m. And obviously, and you know, this isn't normal. They do this with every hearing. I don't know if they, you know what? I'm going to pull back on that statement because I could be wrong about how they do put notice of hearings out, obviously. But I don't know if they go into this much detail of what they're going to be discussing at the hearing. And they probably, if they don't normally do this, they're doing this specifically for Sarah to understand what to expect and not ask so many damn questions. And I get this. I mean, again, crossing T's and dotting I's, right? Okay. So they're going to schedule a deadline regarding production of state's exhibits and defendant's exhibits. They're going to schedule a conference for the defendant to review all of state's exhibits in the courtroom 12A. So they've got to have a separate time set aside for them to go back into the courtroom and let her see all of the evidence. Wow. Okay. Scheduling a deadline for receiving defendant's objections to state's exhibits. Scheduling a conference. This is all just, these are basically setting deadlines. Scheduling a conference for the state to view all the defendant's exhibits in courtroom 12A. $20 says that there's no way they're going to not go back to court before the September 24th conference hearing. We're probably, I would imagine, they're going to reschedule some more stuff probably in the next 2 weeks to kind of stay on track of this. Scheduling a deadline for receiving state's objection to the defendant's exhibits. Scheduling a deadline regarding production of state's witness list and defendant's witness list. Scheduling a deadline for receiving defendant's objections to state witness list. Scheduling a deadline for receiving state's objection to defendant's witness list. And the defendant's temporary motion for reservation of proposed cost to acquire investigator for defendant's defense in the trial dated July the 18th and received July 29th. Defendant's temporary motion for reservation of proposed cost. Okay. So they're going to go over her motions. All of them here. All 5 of them. So that's what we're going to get on Monday. I have a feeling that this poor judge is going to have to spend a lot more time with Sarah than he wants to. Because there's no way she's not going to ask 20 million questions. That being said, he was pretty matter of fact in the last meeting. When she started asking questions, he was like, ma'am, I cannot answer that question. You have been charged to defend yourself, and I'm not. He's basically, she's going to wish she had Judge Giroux. Let me put it that way. Oh my God, I would love to have seen her and Judge Giroux together. That would have been awesome. All right, what else we got here on the docket? This is just going over the minutes from the last court meeting where they basically said, you know, meet investigator Billy Lane. He's with Prison Break Investigations. He's assigned to your case. Where the judge also told him, look, do whatever you got to do to get all of the discovery on a USB drive or USB drives, plural, so that we can get it over to her. So it's going to be them handing stuff over on August the 5th, and she's going to stay in court on August the 5th. I cannot believe that between the last time that we met and now, you have not given me any more information. I'm still waiting for my discovery items. I have lost a week's worth of time in working on my case. And then she's probably going to ask him again for an extension. And he's going to say, nope, I told you, nope. So at that point, on Monday, he's got to turn this USB drive over to a representative from the Orange County Jail so that they can place it onto the laptop that is currently secured and issued to the defendant for the court trial preparations. Looks like that's it. So today's Thursday that I'm recording this, and we'll have to wait till Monday to see what happens from here. So you guys, basically, you now have everything that was on the court docket.
What's up, Boonies? As mentioned in her last court appearance Friday morning, Sarah has written a letter to the jail captain, Giovanni, So let's get to it. Okay, this is an 8-page letter referencing her questions and concerns for laptop, phone, etc. Captain Di Giovanni, thank you for your timely cooperation and assistance in me receiving my laptop yesterday and 2 Discovery USB drivers supplied by my investigator. I am attempting to fully maximize my opportunities available from OCCD to thrive in my forced position as court-appointed pro se defendant and the success of my case. Surprised she didn't mention she was an indigent again. I want to excel in my present circumstances, but attempting my best and have been since day one of my incarceration ongoing 5 years ago. As you can imagine, I do not want to be here any longer, ever with the hopeful, effortless cooperation and attentive care from yourself and OCCD. I believe I can achieve more efficiently, effectively, equally, so I am able to plan my very overdue exit in the very near future. Really, Sarah? Let me reread that. So I am able to plan my very overdue exit in the very near future. Girl. She's delusional. I have been instructed to contact you directly for the listed questions and concerns to hopefully remedy or provide further insight to or for completion of, so there is universal understanding to enable me to produce greater, faster results and work product in my case and defense. Thank you in advance. Why does she say profusely? Profusely. Does that even go there? Oh, okay. Let's first talk about the laptop times. I guess this is what she's asking for. Extend from 8 a.m. through 4 p.m. to 1:30 p.m. to 10 p.m. I am willing and need to vigorously work on my defense as often as possible. I do not think I should be restricted to daytime use only. After 4 p.m., I do not have access to the laptop, which equals zero work product and progress. The building of my defense is halted for 16 hours until the next morning. Request to extend times to use by 2.5 hours in the evening. USB drive security. As stated in court to the judge, I do not feel comfortable in handing over the entire contents of my case to the miscellaneous officer in the dorm for the day. All of my information is highly confidential, and I'm trying to avoid further leaks on top of the already recorded jail phone calls, visitation names and details, my inmate interaction, meals consumed, etc. I have no idea what she's talking about because I've looked. I haven't seen anything else. If y'all know that there's something else out there, will you please put it in the comments below so I can go track it down and we look at it here on my channel? A concerning example today, I returned the laptop and USB drives together yesterday. I received back the laptop, which is not charged at all for instant use, and the USB drivers separated with the protocol security paperwork removed. I needed, and then both bags resealed. Another example, I went to pick up everything in the morning, and the officer removed both USB drives from the bags before giving to me. Who is in control of the laptop and my 2 USB drives when I return at the end of each day? Where do they go? How are they secured? Why are contents being removed, opened? See, I kind of think she's doing this just to set up the whole appeal process. But then again, I don't know. She's not as smart as she thinks she is. As said, I do not feel secure in this process if there is one, and it is vital to me that OCCD handles with priority, safety, security, and care. When asking any officer anything pertaining to the laptop and driver, they do not know and become agitated with me trying to ask and figure anything out. Oh no, she's not agitating them, is she? No way, not Sarah. Allow me to keep only the 2 USB drivers at my bunk after returning the laptop to keep in my secured locked drawer each day, hopeful evenings. Yeah, no. Is this the same bunk area that she said she did not feel like she had any privacy and it wasn't secured? Classroom. This room is unoccupied for the majority of each day, and an available, close, undisruptive solution for me to achieve privacy to reviewing and listening to my confidential case documents. The classroom is also in direct, continuous, effortless view of the officers at all times. Request: remit me access to utilize a table in the classroom to view and listen to my discovery on the laptop when not occupied and is in direct view of the officers. I love how she just goes in there's like, this is how you should run your jail. Earphones and headphones. As said, my discovery contains a large amount of audio to be listened to. If you will not permit me access to the classroom, I will need listening abilities with earphones or headphones over the ever-increasing noise level of the dorm. These are also a must when the dorm is on lockdown and quiet, so no one is able to hear. Request is to provide any kind of earphones or headphones. I wish I kind of saw that atmosphere that she was in. I want to understand it because I'm a little bit confused about how that's set up. She keeps referring to it as a dorm. I've never heard that in a jail before. Internet with limited access and restrictions. I need to research heavily my defense, all of it. Locate witnesses, any experts, the clerk's website, correspond with the judge, my defense team, anyone affiliated, or maybe with my case, forward motions, other important documents, everything I need to educate myself on or about being pro se, etc. Please understand I cannot complete any of the aforementioned without internet. The basic laptop provided is only for viewing my USB drives. There is no other access. The request is, grant me access to the internet with appropriate parental controls and limited access with restrictions. Word program. To type any motions, make notes, lists, memos, anything I need to document and record for future reference or sharing with potential team members. Girl, you ain't got no team. You ain't got no team. I need to be able to open and create a document, save work product information, attach text and PDF documents created to email if granted, print needed documents or discovery pages for mailing, sharing, presenting, or distributing. Request: permit access to Word program to use fully, properly, and progressively. Telephone access. As you are aware, my dorm contains payphones only and are limited to only 15 minutes per call, which are collect. I need to be able to communicate on a regular, normal phone to make any and all necessary calls for my case to use in trial. I have no other way to contact anyone that is not collect, which incredibly diminishes most, if not all, of my opportunities to properly prepare. Request: permit reaccess to a regular normal phone to communicate reasonably with parties in my case and any new futuristically to be affiliated with. It really, really bugs me when she uses that word futuristically. Discovery hard copies. As I am presently, I can keep these in the permitted property bag discreetly located at my bunk. I will purge the document I have now and keep only my discovery hard copies. The remaining I can send to the property department and will purge anything already being stored for easy convenience and extra space. I hate her handwriting. Also, when the laptop hours are closed, I am able to pick up uninterrupted with these hard copies at any time. Any comparative review with digital can also be achieved. Request: permit my hard copy discoveries to be received and kept unnoticed at my bunk for readily available viewing and unrestricted access. Oh, now she gets into her feelings. Okay. Captain D. Giovanni, everyone's understanding and invaluable time is greatly appreciated in this assistance in aiding me to utilize my capabilities and opportunities here at OCCD. I am diligently working on what I can with what I have and am severely hindered in real progress without my request, especially needing to access the internet and a normal functioning telephone. Becoming pro se defendant was not my choice. I am already trying to overcome my extreme circumstances just in my life of incarceration, and now, in addition, being forced by the court to represent and defend myself in my criminal case. Extreme has progressed to extraordinary. Whatever. Please understand my attempts are always in good faith, where I am simply trying to complete these tasks needed to surpass my difficulties and achieve overdue success. And finally, I cannot do it without you and the assistance of the Orange County Corrections Department. I thank you, everyone, for your patience and await your response for needed collaboration and conclusion of my request, please, and criminal case. God, I hate the way she writes sentences. I have notified the judge also with a copy of this letter, so he is aware I am in the process of trying to receive these must-haves and that I need further guidance and answers from you first. From there, I can create all motions that may be necessary for access and completion. This is important, Captain, and time sensitive, as my proposed trial date is on October the 7th. As of this letter, I have only 59 days for the completion of my defense prior. Please understand the importance of your timely attention and response. As said, I cannot do this without you and the help of OCCD. I am beyond grateful. Please notify me as soon as possible, please, about any motions I need to file for my request to be granted. Thank you immensely. No. I would have said immensely if she was going to put a word there, but she says immeasurably. I'm thinking that's what that is. Thank you immeasurably. Sarah Boone, number 20005623, FDC-B4. Pro se indigent, defendant, inmate. P.S. I also spoke to Sergeant Casey in the courtroom requesting your time, please, at your earliest convenience to convey the importance of my request to hopefully be completed. Well, that wasn't as bad as I thought it was going to be, I have to be honest. I think there's some more on the docket that I have to get to, but I need to digest this letter from Sarah first. And I wanted to get it out there to you guys as soon as possible.
I'm not a bad person because of that. Not my fault. Not my fault. Not my fault. I'm not a bad person because of that.
Thanks for watching, everyone. If you enjoyed this video, please do not forget to like and subscribe on your way out, and feel free to leave a comment. Have a blessed day.